mom with a plan, and she knows how to sell some weed. That's right. It is Sacramento's own, the Canagram favorite. That's right. It is Manndie Tingler. You're on mute.
I hate when I'm trying to be a good correspondent and mute for everything, and then I forget to unmute and look stupid. Sorry. Anyway, here we go, guys. Today's article is something that's a very hot topic in my world these days. Figuring out how medical cannabis is not really being considered to be covered by medical insurance yet. There's a lot of discussion that needs to be had here. And this article comes out of Pennsylvania Commonwealth. The court rules that workers' comp should cover medical marijuana costs. It says in Harrisburg, Commonwealth Court has ruled that workers' compensation should cover the cost of medical marijuana for treatment of injuries suffered on the job. The court on Friday handed down 2 decisions in cases brought by workers who were hurt on the job and were initially prescribed opioids for treatment. But in both cases, the workers sought to get their costs of medical marijuana covered by workers' compensation, asserting that the marijuana has been more effective in treating their pain. Winston, sorry, he really cares about this. In Teresa L. Fegley as executrix of the estate of Paul Sheets versus Firestone Tire and Rubber, a workers' compensation appeal board. Sheets had been injured at work in 1977, according to the opinion written by Judge Ann Covey. He underwent 2 back surgeries, and over the years, he treated his pain with opioids and narcotics. In 2019, at the recommendation of his doctor, he began using medical marijuana to deal with his back pain in the hope of eliminating the need for opiates and narcotics that he had been taking for approximately 30 years. Medical marijuana afforded claimant pain relief and reduced his need for the opiates and narcotics, according to Judge Covey's opinion. She added that Sheets also reported that taking medical marijuana apparently provided psychological benefits in 2019. He began seeking to have the cost of his medical marijuana covered by his workers' comp. Sheets died before the court made its decision, and his estate continued the case. In the case of Edward Apple versus GWC Warranty Corporation, Mr. Apple was injured at work in 2006 and was prescribed opioids for the pain. He obtained a medical marijuana card in April of 2018, and by September of that year, he weaned himself off of all opioid medication, despite suffering a tremendous amount of withdrawals during that process, according to a separate opinion also written by Judge Covey. In October 2018, he sought to get workers' compensation to cover the cost of his medical marijuana. In both cases, their claims were denied, and the appeals board upheld those denials, but Commonwealth Court decisions reversed the appeals board. In the decisions, the court concluded that while the medical marijuana law includes language specifically decreeing that insurance companies aren't required to cover the cost of medical marijuana, it also includes language that medical marijuana patients should not be denied any right for lawful use of medical marijuana. As a result, the judges reasoned that, quote, the General Assembly explicitly intended Commonwealth residents suffering from irretractable pain to have the benefit of this therapy, and at the same time chose not to limit claimants from receiving their statutory rights. The judge also decreed that employers are not being ordered to break federal law because they are not being required to pay for the marijuana, but rather they would be reimbursing the patients for their medical costs. Judge Christine Fasano-Cannon filed a dissenting opinion arguing that the law's ban on requiring the insurers to cover the cost of medical marijuana should be the deciding factor. Claimants argue that because the WC Act is liberally construed, the MMA should not be interpreted to, God, I can't even talk today. The MMA should not be interpreted to preclude reimbursement that is otherwise required by the WC Act. The most obvious flaw in this argument is that prior to the enactment of the MMA, there was no legal medical marijuana in Pennsylvania, and therefore no reimbursement was required under the Act. Judge Fasano-Cannon noted that the legislator apparently didn't require insurers to cover medical marijuana because the U.S. Food and Drug Administration had not approved the use of the drug for medical conditions. So guys, this is a really hot topic. This is a very important piece for all of us, especially for people who are really in chronic pain and have been precluded from being able to work due to these things. I'm really interested to see what the rest of you think about it. This is groundbreaking in so many ways. And this is Mandy from High at Nine.